and welcome to this edition of the India Development Debate. I'm Nayantara coming to you from a very cold night in the national capital. From Vijay Chowk, behind me is of course Rashtrapati Bhavan, and a stone's throw away from here is the Supreme Court of India, which is going to be hearing the crucial case between Tata Sons and Cyrus Mistry come tomorrow. The Chief Justice of India has going to be holding the hearing for this very crucial case, and we thought this should indeed be the big topic of discussion today on the India Development Debate. So much riding on it, not just the future of several Tata Group companies, but the important precedent that has been created by the NCLAT. Joining me today to talk more about that is Mohit Saraf from LNL, Tushaad Cooper, Senior Legal Counsel, as well as Sanjay Asher, the Senior Partner at Crawford, Bailey and Company. Gentlemen, thank you so much for joining us here on the India Development Debate. Tomorrow, of course, a big day for Tata Sons as well as Cyrus Mistry. Mohit Saraf, if I could come to you first. In a sense, this is now going to be more about what's it going to mean for Cyrus Mistry to get nominee directorship at Tata Sons. He's already given up and made it quite clear in a public statement that in the larger interests of the Tata Group companies and Tata Sons, of which he's one of the largest shareholders, he's not pursuing directorship. He's not interested in being the chairman and managing director.
I think that's a fair point. I think, in my view, he understands that this order of NCLAT would get vacated, whether before on the admission itself or after the hearing, because it is against the basic companies law and corporate democracy. So I think he's positioning himself, and I think the more important is for him is because he's an 18% shareholder. He's trying to see how he can protect as a minority shareholders, and he can at least enhance his value of his investment. So I would say that is probably makes sense, and that's the reason the change in position, because he understands that his case is very weak on law, and Supreme Court will definitely only look at the law and not look at anything else. So I would say it's a positioning issue, but I think it's a fair climb down, and I won't be surprised that on a preliminary hearing, the Supreme Court comes up and stays the entire operation of the order till the case is decided, because this compromises the entire corporate law of India. It compromises corporate democracy. So it can be a very big day tomorrow, and hopefully the courts will set the trend and at least will not create more confusion on ease of doing business, on corporate democracy and things like that.
That's right. It is, of course, going to be a big day, and that's why this curtain raiser on the India Development Debate. Tushaad Cooper, if I could come to you now. Besides discussing the future rights of minority shareholders vis-a-vis the company's law and that crucial NCLAT verdict in this case, let's also not forget, and if you read the various appeals that have been filed by Tata Sons, Ratan Tata, as well as the Tata Group companies like TCS, they all seem to be distancing themselves from the ROC that decided on the action of converting Tata Sons from public to private. The question I want to ask you is that, okay, you can look at this in this large corporate boardroom battle, but it's going to have a huge precedent on corporate India, on how businesses are run across India, because if you're going to let this happen, wouldn't it be a fair assumption to say that you could suddenly see a whole host of companies that will be filing similarly before the ROC, and then why shouldn't they be converted to private?
Quite right. I agree with you that the precedent of conversion of the company from a public company into a private company, as was sought to be done in the instant case, does require closer scrutiny and should be examined carefully by the Supreme Court. But my belief is that tomorrow's hearing is not going to consider all these issues. It will be a preliminary hearing, and therefore, probably the only question which would arise is that there's no doubt that leave will be granted in these appeals, as they do raise very substantial questions of law, and also in view of the divergence on factual findings, both by the NCLT vis-a-vis the NCLAT, I think the Supreme Court will examine the matter in depth. So having said that, yes, tomorrow's hearing will be a preliminary hearing. I do believe that the court in all probability will direct the status quo to continue. It possibly may direct the parties to a mediation and sort of suggest that keep the matter after 4 weeks and let the parties try and attempt to resolve the issues through an amicable mediation. I don't believe that this is a climb down by the Mistry camp by renouncing claim to an executive directorship in the Tata companies. This is because the Mistry camp never sought for any executive directorship in the Tata companies. So really it is not a climb down. It was something which was granted by the NCLAT, which I do believe was perhaps untenable. And the Mistry camp, in recognition of that, is likely not seeking to press for that part of the order to be sustained. So yes, it will be an interesting battle ahead, but nothing of substance is likely to be decided tomorrow. The appeals will in all likelihood be admitted, leave will be granted, probably status quo will be directed to continue, and perhaps a mediation will be directed to take place.
Right. If I could, it's a very important point that you're making, that while it is one of the largest corporate boardroom battles that we've seen since maybe that between Mukesh Ambani and Anil Ambani, let's not get ahead of ourselves. Of course, it's huge, it's massive. We're talking about Cyrus Mistry versus Ratan Tata. It's sexy for all the journalists to track as well. But Sanjay Asher, if I could come to you, very relevant points that are also being raised right now by Tushaad. But I want to ask you exactly what I asked Tushaad right now. It is the Tata Sons strategy, it is Ratan Tata's strategy, Venu Srinivasan's strategy, the Tata Group company strategy to distance themselves from what the ROC, that is the Ministry of Corporate Affairs, did in the conversion from public to private. But it has massive ramifications as well. Where do you stand on this one?
Yes, there would be massive ramifications on conversion from a public company to a private company. But at the same time, the law permits you to convert a company from a public company into a private company. If majority of the shareholders, and those shareholders are Tata Trusts, it's going to affect not only the minority shareholder, which is the Mistry camp, but it is going to affect the entire group of shareholders, including the minority shareholders. So to my mind, there is nothing wrong if there is a motion which has been placed or a resolution which is passed for conversion of a public company into a private company. If you restrain any company and its shareholders to prevent that company to getting converted into a private company, then what is the point in having that particular provision in law, when it is going to affect the entire class of shareholders, the entire equity shareholders of the company? How can we prevent a company or its shareholders from converting the company into a private company? If at all it is upheld that, look, the shareholders cannot convert, or if the court prohibits the conversion of a public company to a private company, again, as Mohit stated, that as far as the directorships are concerned, or as far as the removal or the appointment of directors are concerned, similarly, this is corporate democracy. By not permitting conversion of a public company to a private company, again is going to put the entire corporate democracy into a question mark.
Right. Mohit Saraf, if I can come to you now, and we've seen some very strongly worded appeals filed by the Tata Group, Ratan Tata, the Tata Sons. I want to come to Ratan Tata's appeal at the Supreme Court, where he says, coming into the issue of replacement of Mr. Cyrus Mistry as the chairman, in the months preceding his eventful replacement, the relationship between Mr. Cyrus Mistry and the Tata Trust had become discordant. And it was strongly felt by the Tata Trust that he could not provide robust leadership to Tata Sons in future. Amongst the various fronts where Mr. Cyrus Mistry's leadership was lacking was his reluctance to timely and meaningfully disassociate himself from his family business after he became the chairman of Tata Sons. slowly and systematically, he had also concentrated power and authority in his own hands as chairman in all major Tata operating companies where there was no longer any representatives from the board of the company. This is Ratan Tata that we're talking about, his appeal before the Supreme Court, and a very serious charge he's levelling against Cyrus Mistry. I want to read that along with the Tata Sons appeal, that how the NCLAT has undermined corporate democracy, that what's going to happen to the rights of the shareholders and the board of directors if we see a judgment like this which must be struck down. How should one read all of this? Ratan Tata making it very clear that Cyrus Mistry had lost the confidence of the board, had lost the confidence of Tata Trust, and therefore they're within their rights to throw him out.
Absolutely correct. Actually, Tata Sons appointed Cyrus Mistry as its nominee. They did not, Cyrus was not appointed by a minority shareholder. It was Tata Sons as a majority shareholder appointed Cyrus Mistry as its nominee. It is just an accident that he also happens to be the minority shareholder. So if the majority shareholder had lost trust in an individual, and that individual does not represent minority shareholder, then he has within its rights to remove him. That's a standard thing. It's really any company, if the board of directors have lost faith or trust in the CEO, he will be removed. And what's wrong in it? It's a commercial decision. This is not a decision which courts can look at it and say whether the removal was right or not. Yes, if there was a breach of the appointment letter or something like that, the courts can look at it. Otherwise, courts have no role to play. That's number one. Number two is that what you just read out is that he's saying that there was a conflict of interest because Cyrus Mistry also has its own group of companies, and obviously that is a question of fact. And if Mr. Tata has some grounds to say that, then he's within the rights to say that. Because if there is a conflict of interest and he was not able to distance himself from his ownership and his Cyrus group or Mistry group of companies, then I think it's a fair point that he should be asked to go. And again, this does not need to be proved beyond reasonable doubt. Even an iota of a compromise is good enough for Tata Sons to remove him. There's no problem, actually. The third point what you raised is, again, that he was, if Tata Sons felt that Mr. Mistry was putting himself in the middle of every group company and there was not adequate representation, against as a majority shareholder, as the way they run the company, they are within the rights to look at it. And the courts have no role to play. This is actually, it will be very unfortunate that if the court starts looking into these type of issues. Same thing is as what Sanjay just mentioned, that if a conversion, if the law permits a company to convert from a public to private.
Allow me to come in there, Mohit, because another point that we should bring out, and you're alluding to this part, and Tushaad, I'll lean on your expertise for this. Cyrus's entire case also for being a representative at Tata Sons is resting on the fact of his shareholding of about 18% being the largest shareholder. But then how do you align that with the fact that from 1965 to 1980 there was no representative of the group on the board. From 2004 to 2006 again there was no representative on the board. So when the going is good, it's all fine. The problem is when you have these quasi partnerships or when you are in a joint venture, when the problems start, that's when all of these issues do come out. But how does that work in the spirit of the law?
I think you're absolutely right. I tend to agree both with Mohit and with Sanjay that the right of the majority of shareholders has to be preserved, and corporate democracy does give them that right to remove a director in which they feel a lack of confidence. Having said that, there are two possibilities on the basis of which the NCLAT judgment was premised. One, insofar as the executive directorships are concerned, as I said earlier also, I don't think the NCLAT was right in placing Mr. Mistry back in the executive roles, which he enjoyed. And as you have rightly pointed out, perhaps Mr. Mistry, realizing that also, is not seeking to press that part of the judgment. Insofar as his right to claim a representation on the board is concerned, that emerges from his allegations of oppression and mismanagement. So ordinarily, absent these allegations, in order to prevent further acts of oppression or mismanagement, if in fact they exist, I don't know whether they exist, I don't know whether the material brought out by Mr. Mistry is sufficient to establish misrepresentation or oppression, but the NCLAT came to the view, overruling the NCLT, that there were in fact some acts of oppression and mismanagement, and one of the acts of oppression which it alleged was inter alia the attempt to convert the company from a public company into a private company. I agree with Mohit and Sanjay that there has to be a right to convert such companies. There is the law which provides for that, provided the procedure is followed. What the NCLAT seems to have concluded is that that procedure was not followed. And it is for that reason that they have struck down the conversion by Tata Sons to convert itself from a public company into a private company. So nobody can deny the fact that the law provides for such conversion and such conversion can take place. On the aspect as to whether the NCLAT was right or wrong in putting him into position of directorships, in spite of the fact that there was no uninterrupted continuous course of conduct which suggested that he had a vested right to have a representation. I agree with you. Ordinarily, this does appear a little extreme. Having said that, as I have also pointed out, given the fact that there are findings of oppression and mismanagement, the NCLAT in its wisdom, in order to put an end to those acts, concluded that it would be desirable for Mr. Mistry to have some representation on the board in order to protect the interests of the minority. As to whether such a judgment will stand or not, that is something we'll have to await from the Supreme Court.
No, 1 second. But I understand what all you agree with and all of that. But I want to understand one thing, and Sanjay, let me come to you. Now, when Sanjay Mistry raises the alarm of oppression, it is after he has been fired. Tata Sons says that the NCLAT, in fact, while saying it's wrong, has failed to even provide reasons for why it is wrong in the way it has been done. It has failed to explain that and give all of the details. But when Sanjay Mistry raises this point of oppression, how do we juxtapose that with the fact that he or no one from the SP group was on the board of Tata Sons from 1965 to 1980 or from 2004 to 2006? You know, how are we supposed to see that? And once again, I'm going to ask you what I was asking the previous panelist. Sanjay, when the going is good, it's all good. When the problem arises is when you see these problems in quasi-partnerships, in the boardrooms, but that doesn't mean it's legally incorrect.
Yeah, absolutely. It's not legally incorrect to appoint somebody as a director or remove somebody as a director. Even where there is a quasi-partnership, even when the going is good, there is no representation on the board, that's fine. It's the minority shareholder's choice whether to be on the board or not to be on the board, or for the majority shareholder to invite a minority shareholder's representative as its nominee on the board. So the point which I am trying to make is that there is nothing wrong that you can appoint somebody or remove somebody as in when you want to appoint or remove somebody. It's question of need of the hour at that point in time. If the need of the hour is that you want somebody to be appointed on the board for a variety of reasons, you surely invite him and appoint him on the board. After a point in time, if the purpose is served or if that person has outlived his utility, then surely you can either ask him to resign or then otherwise you will have to remove him. There is no choice. So in other words, not only in letter, but it meets with the spirit, because appointment of a director or removal of a director, although one may say it's a technical point, at the end of the day, it is a commercial point whether you want to be there on the board or not. And by there being only one individual on the board, it's not going to protect the minority's interest, because minority shareholder is just one person on the board. And at best what he can do is he can give a vote of dissent, and two, he is aware of what is happening, and by merely knowing what is happening is not going to serve the purpose, whether there are board meetings every month or there are board meetings which are the statutory minimum meetings. So in other words, there is nothing wrong if between 1965 to 2000 or 2004 and intermittently if a director from the minority group of shareholders was invited to be appointed on the board and thereafter he was removed. It does meet not only in letter but in spirit as well, in my view.
Okay. You know, the urgency that was earlier being seen, for example, you know, that the TCS boardroom board meet had to take place because of the earnings. That seems to have gone because Cyrus Mistry on Sunday, in a press release, has announced he's not interested in pursuing directorship in the Tata Group companies. He's not interested in being chairman of Tata Sons. Mohit Saraf, final comments to you. That urgency is gone in that sense. So when we do see the case, and you know, we've heard from the rest of the panelists that while it's crucial, don't expect a lot at tomorrow's hearing. Does India Inc. and the legal system and the stakeholders and investors still need a judgment? It's always better to obviously have a decision faster than later, but with that urgency gone, the question I'm trying to get at is that the shroud of doubt that was there over the management, the investors' move, future plans, that's all gone, right?
Nayantara, what you just said is correct. I think the urgency to some extent has come down because of the position which Cyrus Mistry has taken in media, which is a good thing. But again, I think the important issue what Cyrus is really looking at it is how can he use the issues of oppression and mismanagement and get a position on the board, and also protect his right so that he is able to stop the conversion. I think that's really what he's doing. He wants to protect his economic interest, and that's what the fight is all about. And he understands that he has a losing case. And however, if he can build some arguments, if he can put certain facts in front of the court, where he can show oppression, mismanagement, by virtue of which he can say that company being converted to private would enhance or it will create more oppressive situation for him, he probably may have a better case. Otherwise, that's the reason he's come down and he's only focusing on, I think, in enhancing his value of his investment and not focus on all these issues which are very difficult to sustain under law.
And with that, gentlemen, it's a wrap on this debate as far as the Ratan Tata Group versus Cyrus Mistry goes. We at ET Now, needless to say, will be at the Supreme Court tracking that crucial hearing very closely. And you can catch all the twists and all the developments in this big, massive fight between the two corporates right here on the channel.